Hello, this is Jose Coyote, Associate Planner with the City of Oxnard's Community Development Department in the Planning Division. Today I'll be narrating the appeal of the Planning Commissioner's decision to approve special use permit number 21-516-36 for FGH Retail Services LLC for 2320 North Rose Avenue with an assessor's parcel number of 213-0-011-255 for the City Council meeting on December 7, 2021. Project location and existing conditions. The project site is located at 2320 North Rose Avenue. The designations of the site include general plan, which is commercial general CG, and a zoning designation of general commercial C2. The surrounding uses of the site include general commercial C2 and a general plan designation of commercial general CG. As you see viewed here to the right, the vicinity map highlights exactly where this project is to be located, which is adjacent to US 101 and east of Rose Avenue on the northern part of the city. On the bottom here, you'll see a current street view of exactly the configuration, including the shared parking, the major big box store, Best Buy, where the retail shop is going, which is currently a costume temporary store, and then a Goodwill as part of the same shopping center. Taking a closer look, here's the site plan and building elevations. As stated before, to the east will be the existing building, which is the Best Buy. FGH Retail Services will have a cannabis retail facility in the middle, and then just bordering that to the east will be a Goodwill store that's currently in operation. As part of the project, there will be improvements to the facade of the building and the shopping center. As noted here, the major architectural changes will include aluminum products as well as wood-like sort of veneer to go ahead and give it more of a modern look for the storefront. FGH Retail Services Cannabis Permit Timeline. On January 7, 2021, FGH Retail Services LLC filed for a request to obtain a commercial cannabis business permit for a cannabis retail facility during the open application period of a competitive selection process. On March 1, 2021, the city manager approved a list of 13 retail cannabis applicants and 3 local equity applicants that were invited to apply for a special use permit at specific locations based on the competitive selection process. FGH Retail Services LLC was one of those 3 local applicants invited to apply for a special use permit. In order to successfully commence and inaugurate the commercial cannabis business permit, FGH Retail Services LLC is required to receive approval of a special use permit as specified within Oxnard City Code Section 11-457. On October 13, 2021, the Planning Commission approved Planning and Zoning Permit 21-516-36, the request by FGH Retail Services LLC to operate a commercial cannabis retail facility at 2320 North Rose Avenue within an existing 23,275 square foot commercial building. Background: Planning Commission hearing. On October 7, 2021, a public hearing held to consider Planning and Zoning Permit number 21-516-36, requesting approval of a special use permit. Staff recommended approval. At the public hearing, the Commission heard public testimony. Approximately 30 minutes of public verbal testimony was also provided by 12 individuals. Verbal comments received from 8 of the 12 individuals can generally be summarized as being in support of the request, while verbal comments from 4 of the 12 individuals can generally be summarized as postponing their comments to the continued hearing. The public hearing was continued to October 13, 2021. On October 13, 2021, the Commission held the continued public hearing for Planning and Zoning Permit 21-516-36. At the approximately 3-hour public hearing, the Commission heard public testimony. Approximately 75 minutes of public verbal testimony was also provided by 12 individuals. Verbal comments received from 9 of the 12 individuals can be generally summarized as being in support of the request, while verbal comments from 3 of the 12 individuals can generally be summarized as being unsupportive of the request. Following the public testimony and deliberations, the Commission voted 6-0, with 1 commissioner abstaining, to adopt a resolution to approve the project. Then, on October 26, 2021, the appellant filed a timely appeal application with the city. Then on November 17, 2021, the project applicant submitted a letter to the city in response of the appeal. Summary of the appeal. The appellant filed an appeal with 9 grounds of appeal, which are summarized here. 1. No notice was given to the public regarding delivery use. 2. The proposed event space further violates the CCNRs. 3. Background and corrections of incomplete record. 4. The city cannot make the required findings under Oxnard Zoning Code Section 16-531A. Please note that several comments of this appeal were identified by staff as ground of appeal 4. 5. Approval of the application was a waste of the city's time and resources. 6. FGH misrepresented facts in the presentation to the city. 7. The project is subject to CEQA. 8. The resolution itself is flawed and contains many errors that need to be corrected. Note, several components of this appeal were identified by staff under ground of appeal 8. And 9. Request to speak at October 7, 2021 hearing. Appellant grounds of appeal 1 through 2 and staff responses. Ground of appeal 1. No notice was given to the public regarding proposed delivery use. Staff's response. The appellant does not provide any evidence in their appeal application to back up this assertion. 2. FGH applied for a retail cannabis license. State law allows licensed cannabis retailers to deliver cannabis products to customers. Ground of appeal 2. The proposed event space further violates the CCNRs. Staff's response. The city does not enforce private covenant, conditions, and restrictions known as CCNRs. Ground of appeal 3. Background and correction of the incomplete record and staff response. Ground of appeal 3. The neighboring owners submitted a letter to the city on June 15, 2021. The letter's purpose was twofold. 1. Provide the city with the relevant information needed to properly analyze the nature, condition, and development of adjacent uses, buildings, and structures, and to ensure the project does not adversely affect or be materially detrimental to such adjacent uses, buildings, or structures as required by the code. And 2, to put the city on notice that the neighboring owners will enforce the CCNRs, which expressly prohibit adult uses, including cannabis businesses. Staff's response. The commission received notification of the submitted neighborhood owners' letters. The project will allow cannabis retail within an existing building that is located within an existing commercial shopping center. This building is serviced by existing utilities and infrastructure. The project is consistent with public health, safety, and general welfare by city standards and pursuant to Oxnard City Code on commercial cannabis activities to ensure operation standards were met. And finally, the city does not enforce CCNRs. Ground of appeal 4. The city cannot make the required findings under the Oxnard Zoning Code Section 16531A and staff responses. Ground of appeals. Several components were identified and will be listed in the following slides. 4A. The staff report packet before the Planning Commission for the October 7, 2021 hearing does not contain the requirements of Oxnard Zoning Code Section 16-531-A for issuance of a special use permit. The project will adversely affect or be materially detrimental to such adjacent uses, buildings, or structures. Because the project will have an adverse effect on the neighboring uses, the Planning Commission should reject the application as it cannot make the required findings. Staff response. The project staff report, associated attachments, evidence in the record, and the resolution provided the basis of the Commission to find the intent of the special use permit known as SUP, requirements for granting the SUP as specified in the Oxnard City Code Section 16-531. Requirements for granting were made within Section 1 of the resolution. And 2, the Commission made the findings necessary to grant a special use permit were made. Ground of appeal 4B and staff responses. Ground of appeals 4B. Adverse impact on neighborhood uses. There are several adverse impacts on the adjacent usage, which include 1, future tenant restrictions and future tenant residency. 2, financing issues and lending institution. 3, traffic and circulation issues. 4, increase in crime. 5, odor issues. 6, issues with loitering. 7, issues with insurance rate hikes. And 8, loss of business. Staff responses for 4B, which include ground of appeal subsections 1, 2, 7, and 8 as listed above. 1. The claim made by the applicant lacked factual evidence to support their claims. 2. The existing shopping center has been underutilized for years. And 3. FGH proposes to revitalize the shopping center. Staff responds to 4B as listed above for comments for subsections 3, 4, 5, and 6 as listed above. 1. The project was reviewed for compliance with Oxnard City Code and other City of Oxnard requirements prior to the Commission considering the project for approval. And 2. The project was reviewed and conditionally approved to help mitigate any possible odor emitted. Ground of Appeal 4C and 5, and staff responses. Ground of Appeal 4C. The site is governed by a CCNRs which prohibit the following uses. 1. Prohibition on adult uses. 2. Prohibition on illegal uses. Staff's response. The city does not enforce CCNRs. Conversely, the Oxnard City Code allows for cannabis uses with approval of a special use permit, providing findings can be made. Ground of Appeal 5. Approval of the application will be a waste of city's time and resources. The neighboring owners will act to enforce the CCNRs, resulting in the project not opening. Staff response. 1. The city does not enforce CCNRs. And 2. Additionally, the city has a responsibility to process permits that have been submitted for consideration, that are complete, comply with applicable codes and regulations, and have paid the application processing fees. Ground of Appeal 6. FGH misrepresented facts in its presentation to the city, and staff response. Ground of Appeal 6. The project was not transparent with the city and disclosed the strong opposition of the neighboring owners. The staff report attached petition should not have been considered by the Commission. The project violates the CCNRs and has no arguments to rebut this violation and has stubbornly proceeded with its application despite this context. Staff response. 1. The city does not indicate the context of material shown by any applicant team at public or private meetings. 2. Commission was given the petition in full, so the commissioners could review the material and make an independent assessment ahead of the hearing date. 3. City staff were fully aware of the appellant's opposition. And 4. Legal counsel for the project had multiple communications with the city attorney's office in which the project legal counsel disclosed applicant opposition of the project. Ground of Appeal 7. The project is subject to CEQA and staff response. Ground of Appeal 7. The project is not exempt from CEQA process based on the following. The project increased the square footage of the building. Several unusual circumstances apply, rendering the categorical exemption inapplicable in any event. Unusual large size of the project, crime and loitering, odor, noise, and traffic. Staff's response. 1. No building additions were approved as part of the project. The modification was made for the increasing use of additional 275 of existing retail floor area for cannabis retailing. 2. The CEQA categorical exemption, section 15301, existing facilities, and section 15300.2, exceptions to the exemptions apply to this project based on the following. A. The project involves a request to sell retail cannabis products within an existing commercial building previously used to sell retail goods. B. The project request will not increase the square footage of the existing building. C. None of the exceptions defeat the exemption. And D. Crime and loitering are not impacts evaluated as part of CEQA review process. Ground of Appeals 8. The resolution itself is flawed and contains many errors that may be corrected in staff responses. Grounds of Appeal. This Ground of Appeal 8 has several components that were identified. We will begin with 8A and then the following will proceed on the slides. 8A. The Commissioner needs to consider the following resolution condition issues. Imposing a time limit on condition of approvals number 48 through 49 relating to the establishment of a community relations officer. Staff response. 1. Project condition of approval 48 and 49 were modified in the resolution to be considered by the City Council to include a time limit. The resolution condition is as follows. A, condition of approval for 8. The applicant shall provide, excuse me, 8, a condition of approval 48. The applicant shall provide to the city the name, number, telephone number, and email of a community relations officer designated by the applicant. The community relations officer's information shall be provided to the city prior to the issuance of a building permit. The community relations contact shall be responsible for responding to complaints should there arise between the hours of 10 a.m. and 7:01 a.m. 10 p.m. and 7:01 a.m. Complaints shall be addressed within 15 minutes of receiving the initial complaint. B. Condition of approval 49. The applicant shall provide the name, phone number, email address of the business community relations officer to all businesses and residences located within 600 feet of the commercial cannabis business before operation of the business, before issuance of a building permit. The contact name and number shall be permanently posted outside of the facility. Ground of Appeal 8B and staff responses. Ground of Appeal 8B. The project's general plan consistency is not applicable based on the following. The project is not surrounded by cannabis uses which engage in similar retail practices. The project was not reviewed for neighborhood compatibility, architectural design compatibility, security, and overall community benefits. The staff report failed to attach the full set of neighboring owners' letters that was provided to the city in advance of the hearing and did no analysis regarding neighborhood compatibility. Staff response. Cannabis retail uses are allowed within the C2 zoning designation, which with approval of a special use permit pursuant to Oxnard City Code Section 14-473. 2. Zoning neighborhood compatibility. A. The zoning C2 zoning allows by right businesses which engage in general retail sales, department stores, pharmacies, restaurants, and many other uses. B. The project was evaluated for architectural and security as part of the SGP process. C. The letters submitted on June 15, 2021 were made available prior to the commission hearing. Grounds of Appeal 8C through 8D and staff responses. Grounds of Appeal 8C. All references to cultivation exceptions should be stricken, which include condition of approval numbers 85 through 121 based on the project not being evaluated for cannabis cultivation use. Staff response. 1. The project request is solely to allow cannabis retail. 2. Conditions of approval numbers 85 and through 121 are standard conditions for all cannabis uses, so the existing language does not need to be rewritten as the allowed uses are well defined based on the cannabis use awarded. Grounds of Appeal 8D. Condition of approval numbers 102 through 103 need to be changed to cover the entire shopping center's complex instead of within 50 feet of the business to manage loitering. Staff response. 1. Cannabis retail uses have a standard condition drafted by the Oxnard Police Department to limit the security parameter to 50 feet. 2. The project applicant has agreed to help mitigate possible loitering in the shopping center by expanding the parameter of security and entering into a private agreement with the shopping center. Grounds of Appeal 8E and 9 and staff responses. Ground of Appeal 8E. 5. Cannabis deliveries should be prohibited due to there not being public notices of the delivery operation. Conditions of approval reference delivery should be stricken. Staff response. In January 2019, the state legalized cannabis delivery by state licensed firms and eliminated the city's ability to regulate cannabis delivery. 2. In addition, cannabis delivery is considered to be an accessory use to cannabis retail facility. And 3. No changes to the project's conditions are proposed or necessary. Finally, Ground of Appeal 9. Request to speak at October 7, 2021 hearing. The appellant and neighboring owners were unable to be heard at the Planning Commission's hearing. Staff's response. 1. The neighboring owners and their representatives were able to participate in the October 7, 2021 Planning Commission hearing and provided verbal comments at both the October 7th and October 13th, 2021 hearings. Recommendation that the City Council 1. Conduct a public hearing. 2. Find the project to be categorically exempt from environmental review pursuant to the California Environmental Quality Act, known as CEQA, Guidelines Sections 15301 existing facilities, and 3. Adopt a resolution denying the appeal and upholding the Planning Commission's approval of Planning and Zoning Permit Number 21-516-36, Special Use Permit for Cannabis Retail, subject to certain conditions and findings. This concludes staff's presentation of the upcoming Planning Commission or City Council meeting of December 7th, 2021. Staff will be available for further questions at that public meeting. Thank you.